Kwe, Merawalotio, and thank you for watching this video. The purpose of this video today is on treaty education and specifically treaty rights. I want to highlight all the facts that have happened in the past leading up to the current events that are happening today, more specifically Speganegari and the Fishers of Digby. So some of the key words that you are hearing in today's media are treaty, inherent right, and treaty right. So a treaty is a formally concluded and ratified agreement between two nations. An inherent right is a fundamental right practiced by the indigenous people prior to contact and following, such as hunting and fishing. And treaty rights are rights agreed through the signing of a treaty between two or more parties. Specifically, in Nova Scotia, Mi'kmaq have a treaty right for hunting and fishing that you'll see later on. So the two treaties that people are talking about and that are relevant to today's current events are the 1752 Treaty and the 1760 and 61 treaties. So the 1752 Treaty, specifically Article 4, is a signed treaty between the Crown and the Mi'kmaq Nation of the time. And it says that it is agreed that the tribe of Indians shall not be hindered from, but have free liberty of hunting and fishing as usual. I do know that the word Indians is used in this treaty. However, at the time it was common language, but it is referred to the Mi'kmaq Nation. And then we have the 1760 and 61 treaty. These treaties are very relevant to what's happening today because these treaties came from a time of conflict between two nations. So the two nations came together, the Crown at the time and the Mi'kmaq Nation, and it was a bearing up the hatchet ceremony. Basically, the beginning of their peace and friendship, moving forward and living in peace, living together. Following the treaties, we had some major court cases, but the three major court cases that I like to talk about today are the King versus Sylliboy, R versus Marshall, and R versus Sappier and Gray. So King versus Sylliboy court case was in 1927. Gabriel Sylliboy was arrested near Port Hastings for hunting muskrat and possessing pelts out of season. He appealed his conviction to the county court, arguing that as a Mi'kmaq, the Treaty of 1752 recognized the right of his people to freely hunt and fish. So that was the first time the 1752 treaty was used in court. Following that was a big snowball effect. So in 1999, you have the R versus Marshall case. So in 1993, Donald Marshall Jr. was arrested and charged with selling eels without a license, fishing without a license, and fishing during closed season with illegal nets. This is where the moderate livelihood definition comes into play. And the Supreme Court at the time said that the Mi'kmaq had a right to hunt and fish, to fish, earning a moderate livelihood. And moderate livelihood, defined in the court case, includes such basics as food, clothing, housing, and supplemented by a few amenities, but not the accumulation of wealth. So this definition is very broad, and it's not clear and concise as to what they mean exactly by moderate livelihood. So this is where all the conflict is coming from. And then in 2006, I like to mention this court case because it's very similar to the Donald Marshall case in a way that this one refers to harvesting wood, while the Marshall case refers to harvesting fish. So this one says that the indigenous people have an inherent right to harvest wood for domestic use. And the definition of domestic use here is for building houses or heating homes on the Aboriginal community. So this one's very similar in a way. Those are the three main court cases that lead up to some of the events that are happening now. So some of the events that have happened up to 2020 and up to Speganegari and Digby is in 1982, the Constitution Act, Section 35 of the new Constitution said that the existing Aboriginal and treaty rights of the Aboriginal people of Canada are hereby recognized and affirmed. So the 1752 Treaty, the 1760 Treaty, the 1761 Treaty, the Watertown Treaty, the Jay Treaty, all these treaties have been recognized and affirmed, and that they are valid pieces of documentation. So what that meant was that these documents were legal documents. And in 1985, the Union of Nova Scotia Indians and the Native Council of Nova Scotia organized the moose harvest from 1985 to 1989. And each year they were met with conflict. And in 1988, 14 hunters were charged for hunting moose at the time. And the only reason why the Union of Nova Scotia Indians and the Native Council organized these moose harvests was to practice what was originally signed in the Constitution Act in 1982 to 85. So they were trying to put this practice into play. And in 2002, following the 1999 Donald Marshall Jr. case, you have the burnt church crisis. So the underlying cause of this dispute between the Mi'kmaq people and the non-natives was the disagreement of fishing rights in the Miramichi Bay. This resulted in the violent breakout in the region where the Mi'kmaq were mistreated and beaten, boats were rammed and capsized by government vessels, and shots were fired on several occasions. So the Mi'kmaq fishers of Miramichi, burnt church, they were trying to implement their knowledge of the moderate livelihood fishing. So they were fishing for lobster in the Miramichi Bay. And then in 2015, you have the moose call. And I like to add this one because a lot of people think that the moose call that happened in the Cape Breton Highlands was Mi'kmaq driven. However, what a lot of people miss is that the moose call was actually federally funded and was directed by the Parks Canada. So as the last survey in 2015, it was estimated that there are about 1,800 moose in the Highlands National Park, about 2 per square kilometer. In recent decades, those moose have played a role in reducing former strands of fir and spruce in the grassland, so they're eating all the vegetation in the area. More than 120 moose have been killed since the program has started. I think the total number was 122 moose. So what Ottawa was doing was they were flying Aboriginal hunters into the park, and those hunters would remove the carcasses, and the food was distributed to Mi'kmaq communities and food banks across Nova Scotia. The conflict here is that the surrounding communities organized protests to put this to a stop, and in 2019 was the last moose call. I don't think that 2020 would have a moose call, but I've yet to stand corrected. So in 2020, now we have the big event happening in Sibeganegati, and Sibeganegati wanted to do something that our Mi'kmaq people have done for many years, and they wanted to do the moderate livelihood fishing. So Sibeganegati Chief and Council have decided to operate and test moderate livelihood fishing in the lobster fishery, the purpose of which is to determine how much interest there is in moderate livelihood fishing in the community, what contributes as moderate livelihood. This is a big thing because the definition wasn't clear in the Marshall case, and what fishing efforts such as days, traps, and season are required to produce moderate livelihood for our fishers. This was met by resistance from non-Indigenous fishermen, and you can see all kinds of media if you were to go and do a Google search. So that is everything that has happened up to date. So what can you do? Be the solution. I ask you to be the solution, and remember that we are all treaty people. Know the facts, share the story, and here's ways you can help. So take this knowledge and share it with our children. Restore what's wrong, establish connections and build bridges, and be the support someone needs. Walalio, animal tosit.